identical houses across the street, outwardly indistinguishable. Legally, House A exists today, while House B operates under laws frozen in 1995. When the state passes a new property law, like protecting solar panels, both owners expect to benefit. The owner of House A installs their panels without issue. The owner of House B does the exact same thing, but receives a $100 fine from their homeowners association the next morning. If state law generally overrides local rules, then how can a homeowners association legally ignore a newly passed statute? House B is not breaking the law, it is shielded from it. The community is bound only by the legal framework that was active the day its documents were recorded. As a result, modern state laws do not automatically apply to older community associations. This legal freeze depends entirely on a doctrine known as Kaufman language. It is the variable that determines if a community updates with the state or stays locked in the past. The presence or absence of a specific 5-word phrase defines the scope of every homeowner's legal rights and financial obligations. An association's declaration of covenants is a legally binding private contract between the homeowners and the corporation. To understand why a legislature cannot simply change these documents, we look to the United States and Florida constitutions. Both constitutions contain a strict contracts clause. This provision prohibits the government from passing legislation that retroactively impairs or rewrites existing private contracts. Because an HOA is established through a private contract in a specific year, the state is constitutionally barred from forcing modern updates into that contract. This effectively freezes the community's rules in time. This freeze is not absolute. Courts divide new legislation into 2 distinct categories. Procedural laws govern daily mechanics, like meeting notices, and apply to all communities immediately. Substantive laws alter vested property rights, and the Contracts Clause prevents these from reaching older associations. This affects several key areas of community governance. State mandates for board member term limits or requirements for structural reserve funding are substantive. Without the proper language, an older community can legally ignore these updates. While this allows a community to maintain its original rules, it prevents them from adopting modern safety and financial mandates, potentially leading to structural neglect or unrecoverable bad debt. A workaround for this constitutional barrier exists, stemming from a 1977 Florida appellate case, Kaufman v. Shere. The court looked at an association's declaration which stated it was governed by state condominium law, quote, as amended from time to time. By including those specific words, the community provided prior consent. They created an express contractual waiver, agreeing to be bound by future versions of the law. This phrase allows the community to bypass the Contracts Clause. It creates a mechanism where the community automatically ingests every legislative update the state passes in the future. Adopting the Kaufman language creates a strategic dilemma. The benefits include accessing modern financial tools for major repairs and operating under identical state rules. The risk is a loss of autonomy, giving the legislature the ability to alter rules with expensive or intrusive mandates. For communities that have historically kept assessments low by avoiding reserve funding, adopting decades of modern safety laws at once can trigger immediate, significant budget increases. Decades of voluntary adoption created a fragmented landscape where neighboring communities followed different legal eras, eventually prompting legislative intervention. Florida House Bill 657 now requires all newly developed associations to include Kaufman language in their governing documents from day one. The new law also addresses existing associations. Communities currently lacking this language must now hold a formal membership vote to adopt it. Associations can no longer remain passive about their legal standing. The state has required boards to actively select which legal era they will inhabit. To understand their current standing, boards and property managers must audit their governing documents. The first step is locating the preamble, or Section 1, where the community's statutory authority is established. In the references to Chapter 720 or 718, the audit focuses on the presence or absence of the phrase, as amended from time to time. If the phrase is missing, the association is operating outside the modern statutory framework. This can lead to the loss of enforcement lawsuits and significant liability if the board relies on outdated laws. Operating under the rules of the wrong legal year is a primary reason associations lose court cases and incur thousands in opposing attorney fees. The reality of modern property ownership is often not decided by the current governor or the legislature, but by the precise wording drafted decades ago. In these communities, legal power resides in the foundational paperwork, which dictates whether a neighborhood moves forward or remains locked in the past.